All right, so we're here to talk about fair housing. We've got essentially the federal statute, the Fair Housing Act, which we're going to talk about, and then we're going to talk about the Massachusetts standards because they do differ. So the Fair Housing Act came out, and it is being enforced by HUD, the Department of Housing and Urban Development. And they're prohibiting discrimination and intimidation of people in rental and sale transactions. So the act itself is going to define who is in fact protected and what are your responsibilities. So that's just a little introduction. All right, so the Fair Housing Act. It is prohibiting discrimination on the basis of race or color, national origin, religion, sex, familial status, which is including children under the age of 18, living with parents or legal custodians, pregnant women, and people securing custody of children under the age of 18. Same thing with step and adopted parents, as well as disability. So what is it covering? It's covering housing. Most housing, I should say. So it's going to cover owner-occupied buildings, it's going to rentals, sales, all sorts of things. The exemptions are, for example, this is federal because we'll talk about the Massachusetts difference in a moment, is that what is not covered are going to be if there are owner-occupied multifamilies of 4 units. So if one person in 4 units is living in the property, that is not going to be covered. So they are exempt from covering, following the federal Fair Housing Act. The other thing is single-family homes that are sold or rented without a real estate agent. They are also not covered. And then housing that's operated by organizations such as private clubs or churches. Now, how does Massachusetts differ from the Federal Act? They add 9 additional classes. So you see the classes that are listed up here federally, we're now talking about 9 additional ones. So Massachusetts protected classes are going to again be age, ancestry, children, genetic information, marital status, public and or rental assistance, those are protected classes. Sexual orientation, you'll see that is not on there, just sex. Gender identity was just recently added, and veteran and military status. What you'll also see not included in that list, as well as the federal list, are illegal drug users, smokers, sex offenders, people posing direct harm to the public, and animals. But I'm going to put a huge asterisk next to animals because, as you know, there are some protected animals. All right, so what is prohibited? Now we're talking federally again. So in the sale and rental of housing, no one can take any of the following actions based on race, color, religion, sex, disability, familial status, or national origin. So you cannot refuse to rent or sell. You cannot refuse to negotiate. You cannot make housing unavailable. You cannot otherwise deny a dwelling. You cannot set different terms, conditions, or privileges for sale or rental of a dwelling. You cannot provide different housing services or facilities. Falsely deny that housing is available for inspection, sale, or rental. For profit, you can't persuade or try to persuade homeowners to sell or rent dwellings by suggesting that people of a particular race have moved or about to move into the neighborhood, which is blockbusting. This was a new term for me. I actually had to look it up when doing this presentation. One of the cases was actually saying, why don't you go to the grocery store at night? And that was actually considered steering them and discriminatory, because why would you be why else would you go to a grocery store at night? Because they wanted their potential client to see what the community was like, and that was clearly an indicator of discrimination based on race. And again, you cannot deny any person access to in any organization related to the sale or rental of dwellings.
There's a bunch of seats in there.
Yes. So in mortgage lending, so no one can take any of these following actions, again, based on those federal protected classes. Still on federal. So you cannot refuse to make a mortgage loan, refuse to provide information regarding loans, impose different terms or conditions on loans, different rates, points, or fees. You cannot discriminate in the appraisal of the property, refuse to purchase a loan, set different terms or conditions for purchasing a loan. It would also be a violation of the Fair Housing Act to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right or assisting others who exercise the right. Cannot make, print, or publish any statement in connection with the sale or rental of a dwelling which indicates a preference or limitation or discrimination based on those protected classes. This is not only for single family, but also those housing that are otherwise covered. Lenders cannot also refuse to provide homeowners insurance, as well as obviously insurance agencies, based on those protected classes. Other, in the mortgage world, insurance world, is refusing to provide available information on the range of products available, specifically in the insurance world, or print or publish any statement in connection with the provision of insurance coverage that indicates a preference based on a protected class. So I want to go back and talk about the exemption about owner occupied. So all of those, what you cannot do, there is an exemption for owner occupied housing. And in the federal world, we are talking about owner occupied building of 4 dwelling units or less. They are exempt. Massachusetts takes that 4, makes it 2 family. So you can only have that exemption if you are owner occupied in a 2 family. So a little more strict here in Massachusetts. The other thing with respect to the exemptions are those private and religious organizations. They may restrict based on preference as to the enrollment in their organization or employment with their organization or within the church. So the other exemptions that are not protected federally are disability. Massachusetts has carved out disability to include alcoholism, but not substance abuse, which I thought was an interesting carve out. Yeah, isn't that interesting? And under federal law, there's no exemptions for those users of illicit drugs, undocumented immigrants. None of those are going to be protected classes. So we already talked about what is prohibited. All right, so then we talk about children and lead paint. So discrimination against a potential tenant that has a child is prohibited. So that's why you'll see you can never ask for the age of the children residing in a potential rental agreement. Discrimination against renting to those with children on the basis of the potential existence of lead paint is also prohibited. A child is defined as anyone who has not yet reached the age of 18 years old. However, it's also extended to pregnant women or persons who are in the process of adopting or obtaining legal custody of someone under the age of 18. We already talked about mortgage lending.
I think a lot of people thought it was at 6 o'clock.
Yeah.
Oh, that's all right.
Just throwing that out there.
No worries.
I'm thinking late too. Yeah, they changed it.
Come on in.
Oh, yeah, here's the
I double checked this. Yeah. Yeah.
For those of you that haven't signed this yet, it's still passing around.
Perfect. Alright, so this goes back to that block busting. So you cannot make inquiries overtly or indirectly with the goal of trying to figure out if that person is a protected class or not. So again, children, you cannot specifically ask how old are your children, what grade they're in, those sort of types of questions. You know, have you checked with the police station? It's, yeah, you have to be very careful with what you're doing in inquiries. So then these outline practices, one of them is called redlining. So this is the denial of various services to residents of a specific usually racially associated, neighborhoods or communities, whether directly or indirectly, by raising the price. That's called redlining. Then you also have steering. This is also usually racial based, and this is, again, the practice in which real estate agents are guiding prospective clients towards or away certain neighborhoods based on their race and the potential race of the community. So that is obviously discriminatory. There's also discrimination in contracts. So in contract drafting, you have to be leases. You can't, add a child under 18 can't live in this property. That is going to be discriminatory, for example.
No, because I'm going to be up and down.
I know that a lot of time people say, it's a good school system. I would steer away from doing that as well. How you may ask, what's the crime in the area? Like you would say, please defer to your local police department. Same thing with schooling. The schools are all rated online, or you can speak to the superintendent of the school and get more information. But even a simple statement such as, this is a good school area, what makes it good in your opinion? So that could also open you guys up to liability. So definitely things that you want to take consideration there. The standard is kind of like the golden rule. Treat others as you would want to treat yourself. So you have to treat one client the exact same as another. That's really the standard. All right, so if you or someone does have physical or mental disabilities, there's a list here. So this is more disability related. And you have a record of that disability, a housing provider cannot refuse to let you make reasonable, underline, modifications to your dwelling or common use areas at your expense if it may be necessary for you to fully use the housing. So a landlord may permit changes only if you agree to restore the property to its original condition when you move. Housing provider also cannot refuse to make reasonable accommodation in the rules. So not only the actual building, but the rules, policies, and procedures necessary for you to be able to have access to that housing. So here are some examples, and I'm also going to put huge asterisks on animals because we'll talk about that in a bit. So a building with a no pets policy must allow a visually impaired tenant to keep a guide dog. That is a reasonable modification to the rules and policies to fulfill the Fair Housing Act. An apartment complex with unassigned parking must honor a request from a mobility impaired tenant to create a reserved space. That is reasonable modification. So a landlord must do that, or could be considered in violation of the Fair Housing Act. And again, Fair Housing Act does not protect any people who are a direct threat to the health or safety of others or who is using illegal drugs. All right, so after 1991, we have accessibility requirements. Sure, I'm on the same thing. All right, so after 1991, buildings with 4 or more units must have an elevator. The public and common areas must be accessible to persons with disabilities. All doors and hallways must be wide enough for wheelchairs. Units must have an accessible route into and through the unit, have accessible light switches, electrical outlets, thermostats, and other environmental controls, have reinforced bathroom walls to allow later installation of grab bars, and have kitchens and bathrooms that can be used by people in the wheelchairs. If there is a building with 4 or more units that has no elevator and was first occupied after 1991, these standards are only going to apply to the ground floor units. So again, factors that are not included in any protected class, we have already talked about the illegal drug use, registered sex offenders, smoking, smokers, students, animals, asterisks, and then that person who is going to be a direct threat. All right, so we're going to talk a little bit about age for a moment. So again, we have age and familial status is going to protect households which there's a minor children that live with either a parent, a person who has legal custody, or a designee of a parent or custodian with written permission. And that's also, again, extending to pregnant women. Now we have the age on the other end, the older person, which seems hard to say without feeling discriminatory myself. So the Fair Housing Act is exempting some senior housing facilities and communities, because that is kind of positive age discrimination, so to say. They are exempt because these communities can lawfully refuse to sell or rent dwellings to families with minor children or under an age restricted community, such as like those 55-year or older communities. In order for the neighborhood to qualify as housing for older persons, that community must prove that its housing is provided under any state or federal program that HUD has determined to be specifically designed and operated to assist elderly persons, must be intended for and solely occupied by persons 62 years of age or older, or intended and operated for occupancy by persons 55 years or older. In order to qualify for the 55-year or older exemption, that facility or community must satisfy the following requirements. At least 80% of the units must have at least one occupant who is 55 years of age or older. I also don't know about you, but this whole older housing exemption at 55. The facility or community must publish and adhere to policies and procedures that demonstrate the intent to operate as a 55 or older housing. And the facility or community must comply with HUD's regulatory requirements for age verification of residents. This is not protecting senior housing facilities or communities from liability for housing discrimination, and again, based on those further protected classes such as race, color, religion, sex, disability, or national origin. And then this is going to talk about what you can do if you feel that your rights have been violated. So make sure you get that pamphlet. But now I want to go and talk about animals. Because in today's world we have what we know as trained service animals, and then we have the emotional support. Can't even say dogs now, you can say animals. You've got the peacock on the plane. You've got, I think there was recently a literally snake on a plane, one like that too. So, what can you do and not do with respect to animals? All right, so service animals. A resident may only have a pet in a situation where one would be prohibited if that animal is a trained service animal. So a signal dog, a seeing eye dog, or other animal specifically trained to provide service to the disabled. But now we go to Massachusetts. We're a little bit more flexible. So this is emotional support animals must be allowed in Massachusetts, except you have those exceptions where you've got an owner-occupied two-family. So that can be an exemption there. The thing with animals is, what can you do for an accommodation? Because thank you very much, there are certain things that you can do. So how do you get an accommodation for an animal, service animal or emotional support animal? That individual must actually have a disability, which is physical or mental impairment that's going to limit their ability to complete major life activities. That individual must have a disability related for the need of the assistance animal. Okay, so that's a criteria for getting accommodation, but now how do you ask? What is okay to ask?
Well,
So, exactly. So this is their response. So the disability is not apparent. So, again, we're in a non-discrimination seminar, but you can see someone who is visibly blind and they have a service animal. It's apparent. But if that disability is not apparent, so you're thinking more of the mental disabilities, you can't tell from the outset, that housing provider can request further documentation, but you cannot request medical records. So what you can ask for is a letter from a physician, a social worker, or a psychologist, but you cannot actually look for a legal diagnosis of anything. That is if that disability is not apparent. And that is, again, with respect to trained service animals and emotional support animals. So now we've made the request, you got the supporting documentation, it's supported. The only way a housing provider can deny that accommodation request is 2 reasons. That animal poses a risk of harm to others or property of others, and undue financial burden. Those are the only 2 exemptions. One of the cases is increased insurance cost due to this pit bull service emotional support animal a potential reason. Arguably it could be, depending on who the housing provider is. If you're talking about an owner-occupied dwelling unit, the likelihood that it's going to financially impact them with the higher rate, more likely. If it's an investor who has multiple housing complexes, it might not be as cut and dry. But again, us attorneys like these sorts of facts and circumstances test that there's really no cut and dry answer. It's a maybe. Let's leave it up to a judge or jury to determine that. And again, in Massachusetts, that's with respect to both emotional support animals and trained service animals. At this point, it's kind of like you treat them the exact same. So we already talked about you. Does anyone have any questions, by the way? You don't have to just listen to me talk. I can make this about. Okay. Alrighty, we talked about these.
It's good to know about the emotional support animals because it can get very tricky with that.
It can.
Yeah.
It really can, because you're not just seeing dogs or cats anymore,
Yeah.
or hamsters. You're seeing
Peacocks,
pigs. There's definitely getting taken advantage of, but you don't want to say that. So it's
there are people who just automatically registering their animals as emotional
Yeah.
support
Yeah.
animals.
Do it online?
Yeah,
you-
some
Yeah,
people can
basically.
do that.
Okay.
Yeah.
Some you can, yeah.
Okay.
yeah,
Yeah.
some you can.
Because I know like service dogs have to go through like training and
Mhm.
stuff.
Yeah.
Like, I'm sure they get like a certificate, but
Yeah.
like how do you
Service is a lot stricter.
Service
Right.
is different, yeah.
Yeah.
Yeah, but emotional animals.
So I can go online and get my dog as well?
Yeah,
I don't
if you
think we
can
did that.
find a psychologist who's willing to write a letter that
Emotional,
says
she said
it's
it there.
reasonable modification to allow a emotional support peacock in your home, unless you have undue financial burden or that peacock poses harm to others, you have to allow it. It's very interesting.
And you can't charge for pet security,
Nope,
correct?
you cannot charge for pet
Oh.
security. Great point. You cannot do that. So then, what's the inquiry process for disabilities? This is going to be, handicapped. So a landlord's obviously going to be engaging with that prospective tenant. They are going to do a walkthrough of the apartment or the premises to confirm that the tenant will not need those changes, those reasonable accommodations. You cannot have that inquiry if they have any physical or mental disabilities. So obviously if someone's in a wheelchair, it's a little bit different, but you cannot inquire as to their disability. And that landlord should never try to assess that the disabled person's capabilities. For all new construction, owners must set aside a maximum of 10% of their units to be fitted for disabled accessibility. So going back to those reasonable modifications of existing units, so not new constructions. So again, landlords are required to allow or make what we consider reasonable modifications to the units that have already been completed. They're also required to make those reasonable accommodations in rules and policies, which we've talked about. The property owner cannot impose additional cost or rent for this type of housing, again, which is going back to the animals as well. And a landlord cannot refuse to rent to a disabled person because of their needs. And then we go to advertising and marketing. So under the federal law, it's unlawful to make, print, publish, or cause to be made, print, or published in any media, any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination based on a protected class. There are no exemptions to any discriminatory practice in any form of advertising. even an exempt homeowner under the Fair Housing Law does not have the right to employ discriminatory advertising. So just because you're the real estate agent and you abide by this, if then all of a sudden your seller wants to go on Facebook and share your post but saying something extremely discriminatory, that seller can also be violating the Fair Housing Act.
Will you get in trouble?
If it's proven that you directed your client to do that, possible.
But at that point in time, he modified the original post that
Right.
was made, so
Right.
he would just have to prove that.
You would just have to prove that you had nothing to do with
Yeah.
his or her voluntary posting. So what are illegal words, phrases, symbols, and illustrations? So regulations prohibit the use of any words, phrases, photographs, symbols, and illustrations that convey dwellings are available or not available to a particular group of persons because of membership in a protected class. So we are in a world where we're much more visual in terms of our social media marketing. So when you're, doing an open house flyer, just be more wary about, the pictures that you choose to make sure that they're not portraying the ideal or non-ideal buyer. What is the standard of review? Because you could be purely innocent in that. You pull up a template, it's got an image already there. So what is your standard of review in determining that you were not discriminatory? Again, love legalese. It's viewed through the lens of how an ordinary viewer would interpret the offense. That is the standard of review. So again, we go back to the golden rule. Treat others how you would want to be treated. Treat every client as if they are equal. Again, use of human models in advertising. So if you're regularly creating that same template using a young white married couple with a boy and a girl, you might be having some issues. And again, selective use of media, which is going to potentially preclude a certain class, could be considered a violation of fair housing. So you're only advertising in certain geographical areas based on a protected class, or using the equal opportunity slogan or logo here and there. And again, that repetitive selective use of the human models, the images, the graphics that you're using. So the ADA, the Americans with Disability Act, is another federal act. It's also been integrated into the Massachusetts law. So that is protecting an additional class, so not just fair housing, but that is a different statute to protect persons with disabilities from discrimination in employment, transportation, public accommodations, telecommunications, and government services. So fair housing does protect disability, but this is also protecting you in other areas. So again, the Americans with Disability Act requires that reasonable accommodation. State and government properties must follow architectural standards to allow access by disabled persons. The public must comply with non-discrimination requirements that would prohibit exclusion or segregation based on a disability. Same thing with the workplace and transportation services. Now this should look familiar to everyone, and again, I'll make sure you guys get my notes as well. This lovely notice here. So, under mass and federal law, it is required that this poster be displayed. Where is it? So there you go. I did this class with a real estate office a couple months ago, and they had the broker knew where it was. No one else knew where it was.
Yeah,
So
we put it over there on
there
the
you go.
board.
That's a great spot for it. So yes, that is required to be displayed, and it requires that every real estate office and rental office that has public traffic to display that poster in a conspicuous place. So you passed.
Probably should be in the front. But
So when I come back, we'll see if it's moved. Testers. I'm hearing a lot more about testers in a variety of contexts. Recently with mandatory disclosures, I've heard that that's a common one. But we'll talk about testers in the context of trying to find out if someone's being discriminatory. So, testers are legal. What is a tester? Essentially, a tester is someone who is hired to prove discrimination. Likely that person themselves is of a protected class. So there was a case that came out and said, well, how is that legal? Isn't that entrapment? Shouldn't they disclose that to me that they are a tester? Well, the Supreme Court, United States Supreme Court, said no, they don't have to. It's perfectly legal. They don't have to identify their role because treating people with identical procedures and standards should be the common standard. The testers, this was what was interesting as well. The testers themselves, they know that they're going in to try to prove discrimination. If they successfully prove discrimination, not only are they going to get the discriminator whacked with violations, the tester actually has a right to sue that person for damages. Yep, exactly. And the damages that they can be entitled to.
I wouldn't say anything anyways, you know?
Yeah.
What's it to say?
Yeah, so the damages that they could be entitled to are for humiliation, mental anguish, and emotional distress. And courts will give punitive damages, punitive being punishing damages, so there's really no rhyme or reason to the amount that they'll award. So, yeah. And in this case, they tried to argue, well, there was no intent on the part of the tester. They weren't buying, they weren't renting, they were just going in to try to prove discrimination. So why would they be entitled to this sort of these sort of damages? And the Supreme Court that that is a good argument. We live in a world where we're trying to discourage these type of behaviors, so we will allow them to recover these sort of damages to again try to discourage that behavior. So it could happen.
Crazy.
You know, someone could walk into your door and say, you know, I want to look for a house, whether it's rental or something to buy. And again, what is the standard? Treat that person as you would treat every other person so that you do not have any sort of violation. So we talked about federal, we talked about Massachusetts. The governing agency federally is HUD, the Department of Housing and Urban Development. So what is Massachusetts? Massachusetts is the Commission Against Discrimination, so MCAD. That is who is going to be exploring the violations under Massachusetts. A little bit about the history. Massachusetts, being one of the oldest state, has kind of been a pioneer with so many things, healthcare, you name it. The structure of our government is founded from Massachusetts early. So it's not surprising that Massachusetts became a pioneer in anti-discrimination laws and why they have more strict standards than federal. So they really kind of paved the way for the Fair Housing Act as well. Yeah, there's a very different, varying different acts that the commission enforces. So it's not just, fair housing. We're talking about civil rights, public accommodations, sexual harassment, maternity leave, civil rights, and lead paint. So MCAD, that commission, is enforcing all of those different acts. So again, if we're talking about if you think your rights have been violated. So you have your federal way to get your rights protected. You can reach out to HUD, Department of Housing and Urban Development, what you need to provide, name and address, the name and address of the person you're complaining against, identification of the housing involved, description of the allegation, and then where are you going to write. So this is where you're going to go. Massachusetts, you've got your Boston Regional Office there. So that's the Department of Housing and Urban Development. So that is a violation under the Fair Housing Act. But you've got to remember, you also can have a violation under your Massachusetts Fair Housing Act, which MCAD would be your governing source, and you have the ability to reach out to them, and you have to do so within 300 days of the alleged violation if it's employee related, and 12 months if it is a housing related violation. If there's a determination of unlawful discrimination, you're automatically going to be deemed in violation of your license law. So the Board of Registration will automatically suspend your license for a period of 60 days. If there's a second violation within 2 years, there's an automatic minimum 90-day suspension. So they do not have to take further action with the board to get your license suspended. So in addition to your federal state violation, there are civil penalties. The person that has the right to go against you for damages. The civil penalties that are out there, you have $10,000 for the first offense, $25,000 for the second, and potentially $50,000+ for the third violation. And then we talked about federal already.
Can get expensive.
Right. And then that's federal as well. So again, if you think the rights have been discriminated against, you can file the complaint with MCAD. You can file the complaint with HUD. Other than Boston office for HUD, in excuse me, New Bedford, Springfield, and Worcester, there are the MCAD offices as well. And then, of course, it wouldn't be a commission or HUD if you didn't have reasonable accommodations for those with disabilities to be able to have special filing arrangements. So those are available as well, and there any protected class is encouraged to contact the office to make those arrangements. Otherwise, that's all I got.
I just want to make a note too, that if somebody would call you, for an apartment you have, and if they ask you, I see this all the time, if you accept Section 8 or RAPS
Yep.
programs,
Yep, public assistance.
yeah, public assistance, you can't say no on that, and I think that's an important one, so.
Yeah, that was a quick note on that, but yeah, you're right. You cannot, especially in Massachusetts, it's not a protected class federally, but in Massachusetts, you cannot prohibit someone who needs rental assistance.
Rental assistance, so that's an important one.
Yeah, that's a big one, and the animals seem to be
Yeah,
a
the
real
animals,
hot topic
the
right
emotional
now.
support ones.
Now, on the testers, if somebody did kind of sound a little like they
You can
were-
tell.
you can't say anything though. You can't say you're not.
No,
No, because that could be
It's not
considered
right.
discrimination right there.
Yeah.
Well, why are you calling me a tester?
I've had them call me before.
So you just kind of have to play along.
No,
with
you
it.
just play along, and then they ask you, say, just fill out an application, and
Okay.
we'll get to you when we can. That's what we do.
Yep.
So.
Just employ the same practices that you do for all of your clients, and if you have good record keeping of that, you'll be good. What else is going on in the world of real estate that you guys have any questions
I got a
about?
question.
Doesn't have to be about fair housing. I'm here.
I got a question.
Yeah.
I have a two-family that
All
I'm
right.
selling, and I got a tenant on the first floor. They're a pain in the you-know-what. They don't want me to either go in their apartment to show it, and it ties my hands up a
Yeah.
little bit.
Lease or tenant at will?
Yeah, it's tenant at will.
Tenant at will. So this is an interesting conversation because under a lease, you can govern when the landlord has access
Okay.
to the unit. Tenants at will, you do not get that same
So what you're telling me?
section.
I'm not going to tell them that.
No, gosh no. Unfortunately, we live in a state that loves their tenants, and it is very difficult to be a landlord. I always suggest, even if you want to have only tenants at will, you can have leases for tenants at will. They don't have to be year-long leases. You could have tenancy at will agreements that still give you the month-to-month ability to terminate them, but you can also add rules and regulations, such as the marijuana addendum being a big one. Do you
Right.
want people to be able to grow or smoke marijuana? Because that could be considered discriminatory now
Right.
because of the health-related benefits of medical
Yeah.
marijuana. So even if you, only want tenants at will, which a lot of people do, they want the ability to terminate. I still always recommend a tenancy at will agreement.
Now because of the marijuana, can you say no, you don't want anybody smoking in your house, or?
It's going to be interesting to see how that plays out because clearly it's not a protected class yet.
Yeah.
And it certainly will not be federally for God knows how long. But it's not even a protected class in Massachusetts. The argument is going to be, are they going to treat it kind of like emotional support animals? Is it right? Is it going to be you're not allowed to inquire other than being able to get a letter from a physician?
Right.
And I feel like that's coming.
That's coming.
You know, it's coming.
But if you can't smoke in a building, that means you can't smoke, period,
Yeah,
regardless of
well.
what it is.
Well, you
Well,
in
they can
housing,
debate.
It's the same thing
Right.
with pets, right? You can say
Yeah.
you can't have pets, but then allow
Yeah.
emotional support.
And they're using it as medical, so.
yeah.
Yeah.
So if you do not have a lease agreement and you do not have a policy in place in writing that says no smoking, they can smoke cigarettes or marijuana in your house. So you have to have it in writing that it is a rule that there's just no smoking allowed. Then the argument will become eventually down the line
If marijuana would be
becomes
one of
a
those.
protected class. Yeah. Which
I was just, can they make them like? I don't think they could make people go smoke outside. Like if they have like.
Well, cigarettes you can.
yeah,
Yeah,
cigarettes you
cigarettes.
can.
Cigarettes
Yeah.
you
So
can.
if you have, you can prohibit smoking in a home.
Yeah.
But the only way you can do that is if you have an actual policy in place, rules and regulations in place. If that doesn't exist, then they can smoke in the home, whether it's marijuana or cigarettes. If
I
you-
always do tenant and will agreements also.
Oh, I
you
highly
know.
recommend it.
It just sets rules, for the landlord.
It
so.
doesn't mean that you're under a lease forever and that your tenant has these crazy rights, but it gives the landlord a little bit more protection. Access being kind of the big one.
Well, you kind of told them next time you're gonna have to fine for an hour. So I'm hoping it works.
Yeah.
But I was hoping it would be working this time because I'm
Here's a
gonna.
Dunkin' Donuts gift card. Can you go grab some coffee?
Now they want
That
us
would
to come
work.
with masks and gloves on.
Well,
'cause they have a
unfortunately,
baby.
and
So,
again, in
Alright.
tenant Massachusetts, a judge would side by them.
yeah.
Oh yeah,